Good morning. My name is Cynthia Mellon, and I will be presenting today's webinar on protecting the safety and health of temporary workers and OSHA's initiative. I am a safety and health consultant with the Pennsylvania OSHA Consultation Program and have been in the safety and health industry for 30 years. Today's webinar will be pre-recorded. Our chat room will be open to submit questions, and we'll try to answer most of the questions through this chat feature. If we're not able to answer the question during the webinar due to its technical nature, we will post the answer on our website within a week or by October 23rd. This webinar in its entirety will also be posted on our website. So today, the webinar overview the purpose of it is to review the importance of OSHA's temporary work initiative and ways in which temporary workers can be protected. Some of the topics that I'll cover today in the webinar are that OSHA's temporary worker initiative, the definitions that they use, as well as the OSHA NIOSH publication recommended practices number 3735, protecting temporary workers, as well as I want to go over some real-life scenarios. The temporary worker initiative was started to ensure that staffing agencies and host employers understand the responsibilities under the OSHA Act. Temporary workers are entitled to the same safety and health protections as direct hire employees. While the extent of the responsibility under the law of staffing agencies and host employers is dependent on the specific facts of each case, staffing agency and host employers are jointly responsible for maintaining a safe work environment for temporary workers. So what was the background of the temporary worker initiative? OSHA had some concerns that some employers would use temporary workers as a way to avoid meeting all of their compliance obligations under the OSHA Act and other worker protection laws. They also felt that temporary workers were getting placed in a variety of jobs, including the most hazardous jobs. Temporary worker initiative background continued was that temporary workers were also more vulnerable to workplace safety and health hazards and retaliation than workers in traditional employment relationships. Temporary workers were often not given adequate safety and health training or explanations of their duties by either the temporary staffing agency or the host employer. Recent cases include the workers exposed to serious hazards without proper protection and training. And they found this as dangerous heat stress, not temporary employees not having proper personal protective equipment, as well as some were exposed to very dangerous situations and not using lockout tagout. So about 6.5 years ago, OSHA launched the Temporary Work Initiative, and this was to increase OSHA's focus on temporary workers and in order to highlight the employer's responsibilities and ensure that the workers were protected from workplace hazards. OSHA launched this initiative on April 29, 2013, and it highlighted the importance of protecting temporary workers. It instructed the field OSHA people to ensure protections were in place, including training and to gather temporary worker data. At the time, 262 inspections were actually conducted identifying temporary workers exposed to safety and health violations. In July of 2014, a memorandum was sent to all the OSHA regional administrators so that they should provide compliance assistance, develop some outreach materials, as well as meet with national advisory committees, such as the National Advisory Committee on Safety and Health, as well as the Advisory Committee on Construction Safety and Health. The Temporary Worker Initiative actually is still current. So why is it currently still so important? Well, according to the Bureau of Labor Statistics, a May 2017 study, nearly 2 in 5 temporary workers are in production occupations. Temporary workers in May of 2017 were heavily concentrated in production, transportation, and material moving occupations, which are all high hazard industries. The occupations themselves accounted for 39% of temporary workers compared with the 12% of workers in traditional arrangements. OSHA has received and investigated many reports of temporary workers suffering serious or fatal injuries. Some were done in the first days on the job. Numerous studies had also shown that new workers were at a greater increased risk for work-related injury, and most temporary workers would be new workers multiple times a year. Also, the American economy and workforce changing made the use of temporary workers increase in many sectors of the economy. So the other thing that was found was that OSHA's top violations with temporary workers were pretty much not different from those with full-time permanent workers. Some of the violations were usually found in hazard communication, powered industrial trucks, lockout, tagout, machine guarding, fall protection, and electrical safety. So some of the definitions that are key to this initiative: one is temporary workers. And temporary workers are workers hired and paid by a staffing agency and supplied to a host employer to perform work on a temporary basis. The joint employers would be the staffing agency and the host employer. As joint employers, both the host employer and the staffing agency have the responsibility for protecting the safety and health of the temporary worker under OSHA. For example, the staffing agency often would control the employee's paycheck and selects the host employer location. So that would be where the worker would be sent. The host employer in turn would assign a particular work to be done that day and would control the operations in the physical workplace. The joint employment is another definition, and it was put on here because it's actually a legal concept that recognizes in some situations, in quotes, the key attributes of the traditional employer-employee relationship are shared by two or more employers in such a manner that they each bear responsibility for compliance with statutory and regulatory requirements. This definition is actually very important because when OSHA is assessing compliance in any inspection where there's temporary workers concerned, they need to make sure that the compliance officers consider whether each employer has met its responsibility. So here you see the triangular employment and structure. And looking at this, you can see how the relationship is. The host employers must treat temporary workers like any other workers in terms of training with the safety and health protections. The host employer also typically has the primary responsibility for determining the hazards in the workplace, and so they must comply with work-specific requirements. But the staffing agency, as you can see, also has a responsibility. They have the duty to inquire into the conditions of the workers assigned and the workplaces. They must ensure that they're sending their workers to an adequate and safe workplace. Ignorance is no excuse. So they need to also not necessarily become experts of the specific work hazards, but they should actually determine what conditions exist in their client's company, which is the employer, and what hazards their workers may actually encounter. Also, how best to ensure that there's protection for their temporary workers. So, as I was alluding to before in the previous slide, there is a shared responsibility for worker safety and health within the host employer and the staffing agency. There should be a contract between the host employer and the staffing agency, and it should define the relationship and clarify and assign the safety and health duties and responsibilities. Both the employer and the staffing agency should think about the hazards and decide which one is in the better position to prevent and to comply with OSHA standards. Both, though, have the due diligence to inquire and verify. So, continuing on with the joint responsibilities, the extent of the obligation each employer has will depend on the workplace conditions and should be clarified by their agreement or contract. Sometimes their duties will overlap. The staffing agency or the host may be particularly well suited to ensure that the compliance with a particular requirement and may assume the primary responsibility for it. For example, a staffing agency usually would provide the general safety and health training applicable to many different occupational settings, whereas if they sometimes have a long-term continuing relationship with that temporary worker, they could also comply with the requirements of audiometric testing or medical surveillance. The host employer, though, would be primarily responsible for complying with workplace-specific standards relating to and the training tailored to the particular hazards at the workplace. Examples would be looking at machine guarding, the exposure that the temporary worker would have to noise or toxic substances, and other workplace-specific hazards and health requirements. This next slide is going into discussion of the actual publication that OSHA and NIOSH put out, number 3735, Protecting Temporary Workers. So they both got together and actually recommend the following practices to staffing agency and host employers so that they can better protect temporary workers through a mutual cooperation. The publication was written for the purpose of guidance. So some of the recommendations are listed in this slide, and I'll explain each one in detail on the next few slides. The first one is evaluating the employer's work site. So this is prior to accepting a new host employer as a client or a new project from a current client host employer. The staffing agency and the host employer should jointly review the work sites that the worker might foreseeably be sent to, the task assignments, job hazard analysis, etc., in order to identify and eliminate potential safety and health hazards. Also, identify the necessary training and protections for each worker. The staffing agency should provide a document to the host employer that specifies what each temporary worker's specific training and competencies relating to the tasks to be performed are. If the information does become available and shows an inadequacy in such things as the host employer's job hazard analysis or injury and illness reports, or there's an OSHA enforcement history, the staffing agency should probably make an effort to discuss and resolve those issues with the host employer to ensure that the existing hazards are properly assessed and abated to protect the temporary workers, and actually all the workers there. Typically, the host employer does have the safety and health knowledge to control the worksite operations, but the staffing agency could also obviously perform an inspection of the workplace to conduct their own hazard assessment and to make sure that there's implementation of the safety and health program. The second thing is to train the agency staff to recognize safety and health hazards. So many staffing agencies don't have a dedicated safety and health professional, and even when they do, the experts can't be everywhere at once. But by teaching the agency representatives about basic safety principles and the hazards commonly faced by the temporary worker, the agency will be better equipped to discover the hazards that the worker may encounter at the host employer, as well as to try to limit or eliminate the identified workplace hazards before the injury occurs. Number 3 is to ensure that the employer meets or exceeds the other employer's standards. So again, employer could be both the host and the staffing agency, that they need to meet each other's standards. So when feasible, the host employer and staffing agency should exchange and review each other's injury and illness prevention program. The host employer should also request and review the safety training and any certifications that the temporary worker has received who's been assigned to the job. Host employers in certain industries, for example, often only accept bids from hiring staffs that they've previously worked with and have verified that the host employer that the temporary worker has met the host employer's standards. And similarly, some staffing agencies will only work with clients that have a robust safety program. The fourth thing is to assign occupational safety and health responsibilities and define the scope of the work in the contract. The extent of the responsibilities of the staffing agency and the host employer will vary depending on their workplace conditions and should be described in their agreement. So when feasible, the agency host contract should clearly state which employer is actually responsible for safety and health specific duties. And the second thing would be that the tasks that the temporary worker is obviously supposed to perform. So if the job task requires PPE or personal protective equipment, the contract should actually state that, and also which employer will actually provide that. The worker, in turn, should also be informed of any of these details before beginning their job. So clearly defining the scope of the temporary worker's tasks in the agency host contract discourages the host employer from asking the worker then to perform tasks that the worker is not necessarily qualified or trained to perform, and would carry a higher risk of injury. So defining and clarifying and communicating the employer's and workers' responsibilities protects the workers of both the staffing agency and the host employer. Number 3 is the contract should also specify who's responsible for all such communications with the temporary worker. And that should obviously be communicated to the worker before any work begins. Number 5 is illness and injury tracking record keeping. This is a rather long section, and it's because I get many questions about this. There's oftentimes a lot of confusion. But basically, OSHA determines that the responsibility to record is based on whoever supervises the temporary worker on a day-to-day basis. So both the employer and the host employer and the staffing agency should actually track where possible so that they can investigate the cause of the injury or illness. But OSHA, like I said, usually says that it should be kept by the OSHA 300 injury and illness logs, and the 300A should be kept by the employer who is actually providing the day-to-day supervision. Generally, again, with the host employer maintaining the OSHA 300 log, it's because they are required to set up a method for the employees to report the work-related injuries and illnesses promptly, and they need to inform the employee how to report the injuries, even though the staffing agency and the host employer should also inform the temporary employee on the process and how to report the work-related injuries. But initially, obviously, the host employer needs to make sure that the temporary employee is familiar with their system. There should be no policies or programs in place that should discourage the reporting of injury, illnesses, or hazards. Obviously, OSHA prohibits this from employers from retaliating against a worker reporting an injury or filing a workers' compensation claim. Employer knowledge and workplace injuries and investigations of the injuries are vital to preventing future injuries from occurring. So they should inform the injuries to the staffing agency as well, so that the staffing agency can also let other temporary employees know and assist in helping with injury and illness prevention. So if the staffing agency then learns of an injury before the host employer, or because the temporary worker does not tell the host employer, the agency should right away let the host employer know, again, so they can both discuss a way to prevent this illness or injury from happening again. This is really why it's so important to have that agency host contract, because the communication is vital. Number 6 is safety and health training. This is a shared responsibility, again, for assuring that employees are adequately trained. The responsibility for training should be spelled out in the contractual agreement between the both parties. So hazard communication training and powered industrial truck training are good examples of the shared responsibility, and I'll go right into that. So the training responsibilities of the host employer is generally, again, because the host employer will have the site-specific training. It's often in the best position to provide the training because they control the details, the means, the methods, and processes by which the work is to be accomplished. Obviously, the host is, again, most familiar with the hazards of the specific job, tasks, and the machinery and equipment, and the processes of its work site, and will understand the training necessary to protect the workers from the specific hazards. The host employer should also provide the temporary workers with safety training that's identical or equivalent to that provided to their host employers to their own employees. They should also inform the staffing agency when such site-specific training has been completed, so the staffing agency can put that in the worker's file. Other training that's usually conducted by the host employer would be things like first aid treatment, medical treatment, or emergencies, specifically how to identify the exit routes and what to do if they need to evacuate. The staffing agency's responsibilities then are usually generic, and the training needs to be at least so that the worker will have a basic idea of how to identify hazardous situations, how to report the injuries and illnesses, and understand their own rights if confronted with a hazardous situation. This actually would ensure that the temporary employees receive proper site-specific training from the host employer before the work begins, so that, again, if they see a hazardous situation, they know to report that and identify it. If the staffing agency, again, has reason to believe that the site-specific training is not adequate, they need to, of course, inform the host employer, or they could provide the training themselves. The important point to really remember about this is that while the staffing agency may have a representative at the host employer's work site, the presence of that representative does not transfer the responsibilities for site-specific training to the staffing agency. So, again, the staffing agency could provide training, but the host employer is the one that's going to really have the site-specific type of training. So, as I mentioned before, an example of training where staff agency and the host employer would have separate responsibilities. The staffing agency would, obviously maintain a continuing relationship with the employees and is expected to inform the employees of the requirements of the standard. The host employer would hold the primary responsibility here, greatly because the host employer does probably have the chemicals or produce the chemicals. They create and control the hazards, and they're best suited to inform the workers of the chemical hazards specific to that workplace. For powered industrial trucks, or commonly known as forklifts, the staffing agency could conduct the training and evaluation of operators and expect to inform the employees of the requirements of the actual standard. But the host employer must actually, again, provide the site-specific information, training on the use of the particular type of truck, and again, the work-related topics that are present in the workplace that the worker may encounter. Number 7, injury and illness prevention. These are broken up into two categories: the injury and illness prevention program assessments, as well as investigation. So looking at the injury and illness prevention program assessments, the employers both should identify and track performance measures because these are the key to evaluating the program's effectiveness. For both staffing agencies and host employers, a quality program will obviously stipulate how there will be ongoing assessments to evaluate their timeliness and quality and the adequacy of the actual safety and health program. Leading indicators such as training and number of hazards identified and corrected should also be included in the assessments. Generally in speaking, usually to have good assessments, they should take place at least on an annual basis, if not much more frequently. And then recommendations for the program improvement is really what makes the assessments valuable. On the incident, injury, and illness investigation part, in addition to reporting responsibilities, employers should conduct through thorough investigations of injuries and illnesses, including the incidence of close calls, and that's very important. This investigation should be done to determine what the root causes were, what immediate corrective actions are necessary, and what opportunities exist to improve the injury and illness prevention programs. It's critical, again, that both the staffing agency and the host employer are engaged in the partnership when conducting these type of investigations. Number 8, maintain contact with workers. Again, this probably falls more on the staffing agency side because the host employer would be with that temporary worker more often. But the staffing agency should establish methods to maintain the contact with the workers, and it could be as simple as touching base with them by giving them their paychecks or by phone or by email. The staffing agency, though, has the duty to inquire and to all extent feasible verify that the host employer has fulfilled the responsibilities for a safe workplace. The staffing agency should also have a written procedure for workers to report any hazards and instances when a worker's tasks are altered by the host employer from those previously agreed upon. So if there's any changes or anything like that, the staffing agency should be made aware of that. And obviously, the staffing agency should follow up on a worker's safety and health concerns and any complaints with the host employer, as well as investigate any injuries or illnesses or incidents of close calls. I wanted to go from the actual, what OSHA says in the initiative, and kind of touch base here with real life scenarios of how the OSHA standards and requirements are falling in place with in real life. So in the next 3 slides, I want to go over 3 different scenarios. Again, even though this initiative was fully in place over 5 years ago, there's still these real life situations where OSHA has cited both staffing agencies and host employers. So the first one is back in June of this year, fairly recently, that OSHA cited an automobile manufacturer, parts manufacturer, and 2 agencies. They were both cited for exposing employees to safety hazards, and the companies collectively faced a fine of over $145,000. The employer specifically was cited for willfully exposing employees to caught and crushed by hazards. Because they required the employees to operate machines with non-functioning safety laser hazards, that's how why they were cited for that exposure. The 2 staffing agencies that provided the employees to work at the manufacturing facility were also cited as well for exposing the workers to the hazards from the machines with the non-functioning light curtains and safety scanners. And again, this is a key thing because the staffing agency, they should not be ignorant of these types of hazards, these serious hazards. If the staffing agency then, had evaluated the host employer's work site, the employee had been trained on the hazards, the injury may not have happened, or if the temporary employee had been trained maybe to identify hazards, lack of guarding or things like that, again, it may not have happened. So the second one is just more for a temporary agency. This happened last year, that OSHA cited a provider of a temporary agricultural labor for failing to protect employees working in excessive heat after a farm worker succumbed to apparent heat-related symptoms while working in the cornfield. The heat index reached 100 degrees on 2 days in July, and OSHA inspectors determined that the company failed to implement and train employees on heat, injury, and illness prevention program. So remember, back at the beginning of the webinar, I mentioned heat stress was one of the hazards that OSHA had identified that was fairly common in temporary workers. So here's an example of a company being cited. OSHA cited the company for a serious violation of the general duty clause for proposed penalties totaling over $11,000. This third one I added because often people think of staffing agencies only for general industry and not necessarily in the construction industry. And this specifically was a construction inspection. So in May of last year, OSHA cited a construction company and a staffing agency after a temporary employee installing sewer lines suffered a fatal injury in a trench collapse. OSHA issued willful and serious citations to this employer for allowing employees to work in a trench without cave-in protection, for failing to provide a safe means to enter and exit the trench, and not having a competent person inspect the trench to identify potential hazards. The construction company themselves faces almost $140,000 in proposed penalties, and OSHA cited the staffing agency for one serious violation for not ensuring that employees were trained on trenching and excavation hazards. So the staffing agency also faces the maximum allowable fine of $12,934, almost $13,000 in proposed penalties. This next slide is basically a screenshot of OSHA's webpage on protecting temporary workers. And if you look at the bottom of the slide, actually is the link to get to this webpage. Also on this webpage, you can see that there are highlights, and this is actually has on it the initiative of protecting temporary workers, the background policy, and as well as various bulletins talking about specific requirements of this temporary worker initiative. So in summary, staffing agencies have a legal obligation not only to comply with the requirements that are under their exclusive control, but also to monitor the working conditions of their employees at their clients' workplaces. The host employers must treat temporary workers just like any other workers in their firm and train them for training and train them in safety and health procedures. In summary, basically, if there's anything that is a common thread in this webinar, I hope that you leave the presentation knowing that the key is communication between the agency and the host to ensure that the necessary precautions and protections are provided. It's incumbent on both the employers to communicate with each other when a worker is injured and to determine what measures are to be implemented to prevent future injuries from occurring. The communication between the host employer and the staffing agency is really of fundamental importance. So before ending this webinar, I really would like to briefly discuss the program I work for, the on-site Pennsylvania OSHA Consultation Program. The on-site program is designed specifically for small and medium-sized businesses. This is defined as 250 employees at a single site or 500 corporate-wide. Priority assistance is given to employers in high-hazard industries and also those that are involved in hazardous operations. Large businesses that are over 500 corporate-wide or over 250 employees at a single site, the requests would be honored, but they would be probably a limited scope. Because the program objectives are really to promote a better understanding of OSHA standards and to promote voluntary compliance, no company is ever too small for our program. Many companies that we consult with are very small, with 25 employees being the average number. The program was specifically designed for the small employer because the small employer is very unique. Oftentimes they're family owned. The owners of a small company oftentimes wear a lot of hats, and often they do not have safety and health training, and many we found that aren't in compliance even with OSHA standards that are fairly old and have been around a while, such as lockout tagout. So that's what our main objective is to help these type of employers. So the consultation program is very different from OSHA enforcement. We don't issue citations for violations, and we don't issue penalties for violations. The main thing are the employer obligations is that the employer must, however, agree to correct any serious or imminent dangerous hazards that we would identify at their site. We must refer to OSHA enforcement if the employer does refuse to correct these hazards. And I want to back this up by saying that this is a very rare occurrence because companies that submit a request usually, want the service and they want to do the right thing. So they're not even going to get close to not correcting the hazards that we identify. The program is free of charge, and because there are many benefits and savings of working with us, you may also avoid OSHA penalties and litigation costs, reduce workers' compensation costs, minimize equipment damage and product losses. In fact, as it states on this slide, one of our consultants per consultant averages 7 serious and other than serious hazards, and that would save an employer approximately $87,000 in OSHA fines per visit. So that's really a summary of our program. We're located in Indiana, Pennsylvania at the IUP campus. You can always call us directly at 1-800-382-1241, or you can submit a request online on our home webpage. Also, check us out on Facebook and Twitter. Our next webinar will be in a month from now on November 13th. The subject will be multi-employer work sites and independent contractors. I really hope you enjoyed this webinar and learned something from it today. Please feel free to call us if you have any additional questions. Thank you.